So we're continuing to look at the balance between probative value and prejudicial impact of evidence. And remember, as we looked at in the Hitt case in our last video, that we only are allowed to exclude evidence as hypothetical judges if the prejudicial impact substantially outweighs the probative value. Very, very important to keep that in mind. We're looking now specifically at the Old Chief case. And in Old Chief, the defendant's argument is that the government should not be allowed to introduce the specific nature of the prior felony that makes him liable to be convicted of felon in possession of a weapon. The defendant was previously convicted of the crime of assault with bodily injury, and for understandable reasons, he would rather the jury not hear that he is guilty of having hurt someone in the past. There are a number of felonies that could ironically trigger his right not to be able or to eliminate his right to possess a weapon. There are like fraud, tax evasion, trapping a long-tailed lobster out of season is actually a felony, a federal felony, believe it or not. And so he would rather the jury not know what the felony is that leads to him being susceptible to being convicted of being a felon in possession of a weapon. So he's willing to stipulate, look, I was previously convicted of a felony that qualifies under this statute. So if you find that I possessed a weapon, then I'm guilty. And I contest that I actually possessed this weapon. But I don't contest that I'm a felon, and that if I did possess the weapon, that I would be guilty of the crime because I have committed that triggering offense, that prior felony. So the question then is, once he's offered to make this stipulation, is the government still allowed to tell the jury what exactly his prior felony was? And in his opinion for the court, Justice Souter says, one thing we have to be really clear on: this stipulation doesn't render the actual prior crime irrelevant. That it may make it less probative because there might be other ways to prove this now that we have both the stipulation and the judgment of conviction for the assault with serious bodily injury. There might be another way to prove it, which makes the need for this particular method of proof less. But it doesn't make it any less relevant. So this is what I was saying in the last couple of videos. Very often when we think of evidence as being irrelevant, just in sort of like ordinary speaking terms, most often what we are saying is that the prejudicial impact of that evidence substantially outweighs any probative value that it might have. And here in this case, the Supreme Court says, in fact, that's true in this case. And I keep saying in this case because it's a very limited exception. The court holds that as a general matter, and this is a huge point for this opinion, as a general matter, the prosecution gets to tell its story the way it wants to. That he couldn't just stipulate, yes, I had a gun, I'm challenging whether I was a felon or not. The court says that the defendant can, in this case, stipulate to the prior felony because the prior felony is not really a part of the story. And the court goes into a great deal of discussion about the expectations of jurors. I'm not sure I buy what the court's saying here, particularly when we get to, I'll ask you to kind of mark this place and think about what we're talking about in this context when we get to the impeachment of witnesses and character evidence, and how either we can impeach a witness with questions about their past, but not go into extrinsic evidence of it, or how we can or how the defendant can present evidence of his good character, but only in a very summary, routine fashion. We haven't gotten into any of those issues yet. Those are later in the class. Impeachment of witnesses and defendant's presentation of his good character evidence. when we get to both of those, we're going to find that courts are very willing to limit part of the storytelling ability of the defense. But you'll find in Old Chief, the court making a really big deal about the storytelling right of the prosecution. And it really is an irony with the difference between the prosecution and the defense in this way. But the key thing to take away from this is that the defense, that the prosecution is in fact allowed to tell its story. And in Old Chief, the court says there is, however, a very limited exception here where this won't break that storytelling too much, such that it is a violation of Rule 403, that when you have the opportunity to simply say, he does have a felony, ladies and gentlemen of the jury, if in fact he possessed this weapon, then he's guilty of this crime, that's good enough. But it would not be good enough to say, we're challenging the prior. The gun would be part of the story. The defendant could not stipulate away the possession of the weapon. That would be part of the storytelling narrative. Let's say in a bank robbery case, the defendant could not stipulate to the fact that he entered the bank with a gun, and then not allow, therefore, the teller to testify that she saw him enter the bank with a gun. That the court thinks there's something very, very protected about the right of the prosecution to tell its story its own way. And for that reason, Old Chief is an extraordinarily limited ruling about the power of the defendant to stipulate something. If what he's stipulating is not an integral part of the tale being told, then it is something that the defendant can stipulate to, and therefore keep the underlying facts from coming to the jury. And in this case, those underlying facts are the prior conviction. The key takeaway point from this, though, is keep remembering that the prejudicial impact has to substantially outweigh the probative value, and that there is a very limited exception that Old Chief recognizes for stipulations, that you can always make a deal with the prosecution. We'll stipulate to this, and then the prosecution can agree not to put on the evidence. But if the prosecution doesn't agree to take the stipulation as opposed to presenting its own testimony on this question, they don't have to accept the stipulation in exchange for the testimony most of the time. But this is an evolving area of law, and so if you find yourself in a situation where a stipulation would help you, always bring in the principles of the Old Chief case. When you read the first half of the Old Chief case, it's very different than the second half. It sounds like, what use would this evidence ever have once you've offered a stipulation? And then there's the second half of the Old Chief case that really is sort of an ode to prosecutorial storytelling. And those two parts of the opinion are very much in conflict. And so, if I were a defense lawyer practicing today, or even if I were a civil lawyer and as either a plaintiff or defense, and I was trying to keep evidence out, I would not at all hesitate to use Old Chief for the proposition that a stipulation makes the method of proof for that particular proposition less relevant, and therefore more susceptible to exclusion under 403. But for now, understand that Old Chief is a limited exception, but has a very broad reach theoretically, if a court is willing to sort of run with the ideas that Old Chief offer, that a stipulation at least minimizes to some extent the probative value of the underlying facts that you're stipulating to.